Hello and welcome to this podcasted lecture on secret trusts, which will be in a number of parts. Traditionally, this topic is quite popular with students in exams, and it's an interesting demonstration of equity's willingness to be flexible over the common law and even statute when conscience demands it. But what are secret trusts? Well, a secret trust is normally a testamentary trust that usually arises in circumstances where the settlor leaves a legacy in his will on the secret understanding that the legatee, i.e. the person that they've left the legacy to, will hold that property on trust for a third party, i.e. it's intended that they hold the property on trust and don't take absolutely. The will appear to indicate that they do, but their intention is that they don't. So the aims of the session really are to develop an understanding of the development of the law relating to secret trusts and to consider the mechanism by which they operate. Secret trusts, as the label suggests, allow the owner of property to keep the recipients after their death out of public view. By the end of the topic then, we want you to be able to explain the requirements for a will, to review the requirements for a fully secret trust, and evaluate how this is different from a half-secret trust. We'll discuss the theoretical basis for secret trusts and identify and discuss the conflicts that they generate with the Wills Act. So, in order to establish a context, let's begin by reminding ourselves of the basics of the law of succession. When an owner of property dies, that property passes to those entitled under the law of succession. So on the death of the owner of property, the two main methods by which entitlement to that property can be established are either by a valid will or under the intestacy rules. A testator may have made a valid will indicating his chosen beneficiaries and the terms upon which they are to benefit. The other means, though, whereby entitlement on death is established is where a person dies intestate, i.e. without a will. Under these circumstances, there are statutory provisions, the intestacy rules as they're known, which determine which of the deceased relatives take the property. First then, we're going to look at the requirements for a valid will. Why? Well, secret trusts most commonly concern trusts engrafted onto wills and arise where a testator wishes to benefit some person whom he does not wish to name in the will. As a general rule, any purported legacy or testamentary trust which isn't specified in a valid will is ineffective or invalid. An exception to this rule is a mechanism whereby an owner of property is able to determine who is to benefit from that property after his death in blatant contradiction to the clear requirements of the Wills Act through the use of a secret trust. As such, the secret trust operates in contravention of the provisions of the Wills Act and demonstrates equity's willingness to contravene statutory principles in order to achieve a result which it considers to be in line with good conscience. As with inter vivos transfers, there are formality requirements where property is left by will. Now, the relevant formalities are set out here on the slide and can be found in Section 9 of the Wills Act 1837 as amended. Now, Section 9 provides that no will shall be valid unless it is in writing, signed by the testator or by some other person in his presence and by his direction, and it appears that the testator intended by his signature to give effect to the will, and the signature is made or acknowledged by the testator in the presence of two or more witnesses present at the same time, and each witness either attests and signs the will or acknowledges his signature in the presence of the testator. Now, the three key features really here to note are that a will, in order to be valid, must be in writing, signed, and attested by two or more witnesses. If the provisions of Section 9 are not complied with, then the will is completely void, and any dispositions or any trusts which it purports to create will also be invalid. But why the formality? Well, the Wills Act was based on the long-standing principles of the Statute of Fraud 1677, and the key purpose of Section 9 of the Wills Act is to prevent fraud. Only those identified in a valid will should be entitled to receive property on the testator's death. Any alterations to a will done by codicil must also conform to the provisions of the Act, And any arrangements outside of the terms of the will which don't comply with the Wills Act should also be held to be invalid. Now, the reason for all these formal rules then is because to enter into a will is a major transaction, and it has to be proven that it was done as a very deliberate act. The formality requirements prevent false claims on the testator's estate, and as the testator himself is obviously no longer in the picture and around and able to dispute them, we need a formal record. The formal record creates certainty, so we need a written record so that we have something to refer back to. We need it to be signed so that we can be sure that this was actually the intention of the testator themselves. It's for a guarantee of authenticity. We need it to be witnessed, and by more than one person, to ensure that the testator wasn't coerced, so that it actually was entered into of their own volition, as a matter of their own free will. So the need for certainty and clarity is even more important in the context of testamentary transactions than it is in relation to inter vivos gifts. So hence why we have all the formalities in Section 9 of the Wills Act. Now, a secret trust is often, as we will see, arranged through conversations, through discussions, so will often be an oral arrangement. Now, as we've just seen, the Wills Act at Section 9 requires that any testamentary disposition, in order to be valid, comply with Section 9 in that it must be in writing, signed and attested by two or more witnesses. So a secret trust, if it's an oral arrangement, would be strictly invalid under the terms of the Wills Act, because it's an arrangement for the organisation of title in property after the testator's death, which is outside of the terms of the will and outside the terms of the Wills Act. Now, when a person leaves property in a will, then will has to be proved after their death by the executors, showing that it's been validly executed. So they have to apply to court for probate of the will. Now, at this stage, the will becomes a public document which is open to inspection by anyone who is willing to pay the relevant fee. So a will becomes public knowledge. Secret trusts, on the other hand, are intended as private gifts, and a fully secret trust, at the very least, arises where a person, by way of his will, gives property to another, apparently to keep for himself, but actually having indicated to that person that he's to hold the property on a clearly specified trust for an ascertained beneficiary or beneficiaries. The other person must have expressly or impliedly agreed with the grantor to be the trustee of that trust. He cannot then later repudiate the trust and keep the property beneficially on the ground that no will declaring the trust exists. Now, it's obvious that the problem of enforcement of secret trusts stems from the fact that the terms aren't expressed in a form which complies with the requirements of the Wills Act at Section 9 as amended, i.e. that all testamentary dispositions must be in writing, signed by the testator in the presence of two attesting witnesses present at the same time. So if the provisions of the Wills Act were to be strictly applied to the arrangement under a secret trust, i.e. where the ultimate beneficiary is not named on the face of the will, then all such arrangements would be invalid, i.e. the intended beneficiary, the person who the settlor actually wanted to get the property in the end, would not take the property. So is the enforcement of a secret trust in defiance of the Wills Act, or is there a recognised equitable doctrine which allows it to be enforced in spite of the Wills Act? Historically, the justification for its enforcement is the prevention of fraud, i.e. that equity would not permit a statute to be used as a cloak for fraud, which of course would occur if the secret trust was invalidated. And therefore, Section 9, even if applicable, would not be allowed to operate in respect of such a trust. There is a more modern view that a secret trust takes effect outside of the will, and therefore on that basis Section 9 has no application, but more on this in a later part of the podcast. Secret trusts are a device whereby the details of a gift can be kept out of the public domain. We will see that there are two types of secret trust. Firstly, the fully secret trust, And secondly, the half-secret trust, sometimes also referred to as a semi-secret trust. In both instances, the intended beneficiary isn't named on the face of the will, and therefore the disposition would be strictly invalid under the terms of the Wills Act. In fact, the operation of secret trusts drive the proverbial coach and horses straight through the requirements of the Wills Act. But gifts by will are public knowledge. Why should gifts by secret trust, which are kept private, be afforded this apparently favourable treatment? Well, a secret trust arises where the law, or rather equity, recognises a trust relationship to exist in circumstances where to do otherwise would allow a party to be deprived of the property intended. Therefore, so long as the requirements for the proper creation of a secret trust are adhered to, the courts are willing to circumvent fundamental criteria, statutory criteria, in order to achieve what they deem to be a fair and just result. In essence, an equitable obligation is attached to the legacy which outweighs the need for formalities. Think back to the equitable maxims. Equity looks to the intent rather than the form. Equity will not suffer a wrong without a remedy, and perhaps most crucially, equity will not allow a statute to be used as an instrument of fraud. But why the secrecy? Why do settlers create secret trusts? Well, two main reasons can be identified. The first is glaringly obvious, really, as a reason, that is, to maintain secrecy. Now, as we've already discovered, after the settler's death, his will becomes a public document and therefore open to inspection. Now, even if the general public don't take much interest in its contents, and it's unlikely that most of the general public would really care about its contents, the immediate family of the settler almost certainly will care. And a testator may have managed during the course of his lifetime to keep certain things about his private life private, even private from his own family. And he may wish to provide for a mistress or an illegitimate family whose existence he had, during his lifetime, been able to conceal. And he'd be unable to provide for them without naming them as recipients of outright gifts or as beneficiaries under trust created by his will. So in order to get round the fact that a will would then effectively blow his cover and reveal to the world his philandering nature that he managed to suppress during his lifetime, he'd use the device of a secret trust instead, because that's not open to public inspection. Second reason, although this is less supported, is that although the formalities of the Wills Act are easy to comply with, and a new will can always be made to provide for changing circumstances, or indeed amendments can be made to a will through the use of a codicil, some testators change their minds so often that the making of a new will becomes a burden. So such testators may prefer to leave all of their property to one person, say for example their solicitor or a close friend or relative, and instruct that person from time to time as to how they're to distribute the property after the testator's death. So the named beneficiary, in inverted commas, under the will, is really only ever a trustee for the various secret beneficiaries mentioned in the testator's instructions. Now, whilst most commentators would defend the need for secrecy, the latter reason, i.e. for a hesitant testator, has been heavily criticised, and we'll discuss this a little bit later when we look at the justifications and the basis for the operation of secret trusts. Let's just have a brief look at a couple of examples to check understanding so far and confirm that we've assimilated the general formality of the Wills Act and the general principles of secret trusts. So our first example, example 1, Susie signs a document headed My Will, in which she gives legacies to various members of her family and to specified friends. Her signature isn't witnessed. Susie dies. What's the effect of the document, and is there any way by which the intended legatees can enforce the gifts? Now, in answer to those questions, as Susie has made a written document and has signed it, she's on track to comply with Section 9 of the Wills Act, but her signature has not been witnessed. Therefore, the document that she purports to call her will is not in fact a valid will, and the effect of the document is therefore nothing. the intended legatees cannot enforce the gifts, Susie's property would pass on the terms of the statutory rules on intestacy. Example 2. Belinda executes a valid will which complies with Section 9 of the Wills Act, so she's gone a step further than Susie did in example 1. The will contains a legacy of £100 to her friend Caris. Some years later, Belinda decides to increase the amount of the legacy to £500. She crosses out the original figure of £100 and substitutes £500. Belinda dies. What legacy does Caris receive? Now, obviously here, Belinda, unlike Susie, has actually executed a valid will. And so we know that Caris should receive a legacy of some form. Now, the problem here is that Belinda wishes to increase the legacy from £100 to £500. Note from earlier, any amendments to a will done by the process of codicil must also comply with Section 9 of the Wills Act. And here, on the facts that we are given, it does not appear that Belinda has actually done this. She doesn't appear to have had this witnessed and doesn't appear to have signed it according to the requirements of Section 9, this change from £100 to £500. Therefore, by simply crossing out 100 and replacing it with 500, she's done nothing to alter the substance of the valid will, because those amendments would have to comply with Section 9 of the Wills Act and haven't done. So, in terms of the legacy that Caris receives, the original £100 legacy would stand because the amendment is invalid. Finally, example 3, Doreen makes a will in which she leaves a legacy of £1,000 to Edwina. Some months later, Edwina agrees that after Doreen's death, she will pass on the £1,000 to Frank. In other words, Edwina agrees to hold £1,000 on trust for Frank. Doreen dies. How is Doreen able to make a gift on death to Frank without satisfying the requirements of Section 9 of the Wills Act? Well, as we've already seen, she does this by the mechanism of a secret trust. The property has been left to Edwina on the face of the will, but Doreen has had a conversation with Edwina in which Edwina has agreed to hold the property on trust for Frank, and she cannot therefore later repudiate that agreement. She cannot therefore go back on her word and say that she's not holding it on trust. We'll see that this particular type of arrangement on this slide here in example 3 is what's known as a fully secret trust. In summary, for the first part of our podcast, a secret trust or a half-secret trust, sometimes referred to as a semi-secret trust, may take effect on the death of the testator without the need to specify the terms of the trust in the will or even reveal its existence. Secret trusts operate to prevent unconscionable behaviour on the part of the intended trustee and to achieve a result which equity considers to be in line with good conscience. That concludes the first part of our podcasted lecture. In the second part, we will pick up on looking at the formal requirements to how to establish a secret trust of each type, i.e. fully and half secret. Hello and welcome to this, the second part of our podcasted lecture on secret trusts. In the first part, we examined broadly what a secret trust is and reminded ourselves of the basics of the law of succession. So we've seen that a secret trust operates in contravention of the formal statutory requirements that govern the law of succession and a valid will. We're now in this part going to move on to consider the different types of secret trusts and the formal requirements that apply to each. So we start then with a fully secret trust, and fully secret trusts arise where on the face of the will no trust is disclosed and all that appears is an absolute gift or an absolute legacy to the beneficiary, i.e. the beneficiary of the will, who's actually a secret trustee. So a fully secret trust is where a testator leaves property to X, apparently beneficially. For example, I leave £10,000 to Peter and then communicate to Peter his intention that in actual fact he's to hold that property on trust for Penny, which Peter accepts either expressly or impliedly by silence, and therefore at that stage will be bound to hold that property on trust. Contrast that with a half-secret trust. And a half-secret trust arises where the existence of the trust appears on the face of the will, but it's not specified by the testator what the intended trusts are. So, in a half-secret trust, a gift by will is made, but the legatees are identified as trustees on the face of the will, so it's obvious that they aren't to take beneficially. For example, I leave all my property to Joseph on the trust which I have declared to him. So in the second type of secret trust, although the intended beneficiary is again kept off the face of the will, there is clear evidence from the face of the will that the legatee is not to take the property beneficially for themselves, but rather is to hold that property on trust. In terms of the requirements for a fully secret trust, the three-step test emerged from Ottaway and Norman per Justice Brightman. Now, in terms of those three steps, there must firstly be an intention to benefit the claimant beneficiary. Secondly, there must be communication of that intention to the intended secret trustee. And thirdly and finally, there must be acceptance by the secret trustee of that obligation. Now, in terms of the facts of Ottaway and Norman itself, Mr. Ottaway Sr. Had invited his housekeeper, Miss Hodges, into his home a little bit more on a personal level, shall we say, and they got rather close. But he did have an adult son, Mr. Ottaway Jr. But by his will, Mr. Ottaway Sr. left his property, which comprised a bungalow, its contents, half his residuary estate, and a sum of cash, £1,500, to Miss Hodges, his housekeeper, in inverted commas. And this was for her use during her lifetime. But it was on the proviso that she would bequeath this to his son when she died, Mr. Ottaway Jr. Now, subsequently, after Mr. Ottaway Sr.'s death, Miss Hodges and Mr. Ottaway Jr. got along fine initially, but had something of a disagreement, and Miss Hodges fell out with him, and she befriended a couple, a Mr. and Mrs. Norman, and she made out her will, leaving all of her property to Mr. and Mrs. Norman. Now, Mr. Ottaway Jr. challenged this after her death, saying that he was entitled under secret trust principles because she had only been left the property on the basis that she should leave the property to him. And the court upheld this. They said that the requirements were met, apart from in relation to the sum of money. The bungalow and its contents were bound by a secret trust. She was entitled to use it during her lifetime, but then had to leave it to Mr. Ottaway Jr. On her death because she had accepted that obligation when it had been communicated to her by Mr. Ottaway Sr. Mr. Justice Brightman referred to Miss Hodges as the primary donee and Mr. Ottaway Jr. as the secondary donee. Most of the requirements are actually common to both types of trust, i.e. fully and half-secret trust. But the rules for communication of the obligation from testator to the legatee in the will are more restrictive for half-secret trusts, as we'll see a little later. Having a look in a little bit more detail at the individual requirements of the three-step test, we'll start by looking at intention. And with regards to the test for intention, it is similar as to what we're familiar with in respect of express trusts. So as with cases involving precatory words, when we had a look at the three certainties, the initial question is whether the testator intended the donee to be bound by a legal, a formal trustee-like obligation, or merely a moral obligation. And in McCormack and Grogan, the testator left all of his property in a three-line will to his friend, Mr. Grogan. And knowing that he didn't have long to live, he told Grogan of his will and also of a letter containing instructions as to certain bequests. As the letter said, "I do not wish you act strictly to the foregoing instructions. Use your own good judgments. Do as you think I would if living, and as the parties are deserving." And when Grogan excluded a named illegitimate child, it was held that he was entitled to do that because all he was bound by was a moral obligation. He was told to use his own good judgment and as he thought the testator would if still living. So very similar to the cases on preparatory words, free to do as he saw fit with it. In McCormack and Grogan, Lord Justice Christian said, "The real question is what did the testator intend should be the sanction? Was it to be the authority of a court of justice or the conscience of the devisee?" And in the case itself, he said, "In my opinion, expressly and exclusively the latter." So he said it was only a moral obligation in the circumstances of McCormack and Grogan itself. So we're still looking very much like when we were looking at the three certainties for a formal trustee-like obligation. The test for certainty of intention, therefore, is in essence the same, although we refer to different authorities when we're talking specifically about secret trusts. Now, there have been some contrasting approaches of the courts found in some of the subsequent cases, such as Ottaway, Norman and Rees Snowden, which we'll have a look at now on the next. And in Rees Snowden, an undecided testatrix bequeathed her estate to her brother, with the direction, "He shall know what to do." Now, her brother died days after she did, and the niece and nephew brought a claim on the principles of a secret trust, saying, "He shall know what to do," must have obviously meant he shall provide for us. And it was held that actually that wasn't the case at all. There was no secret trust, and that the brother took absolutely, with only a moral obligation to provide for the family members. So the property passed on the terms of his will rather than on the terms of any purported secret trust. So Snowden tells us that it must be a trust obligation and not a moral or a family obligation. And it was stated by McGarry in the case, the more uncertain the terms of the obligation, the more likely it is to be a moral obligation rather than a trust. Many a moral obligation is far too indefinite to be enforceable as a trust. Compare and contrast that with Ottaway, in which Moffat, the author, notes that there is arguably some uncertainty in the terms of the trust, but the trust was nonetheless still upheld. He refers back to the fact that it wasn't clear on the facts of the case whether Miss Hodges could use the money, as that was part of the overall settlement that she was given, along with the bungalow, or whether that was caught with the secret trust, as well as the bungalow and its contents. And he quotes Missouri Bank and Rayner, if you can cast your mind back to when we looked at the three certainties, where it was said, "Uncertainty in the subject of the gift has a reflex action upon the previous words," throwing doubt upon the testator's intention. And Moffat questions whether this renders the terms uncertain and inconsistent with the dictum in Snowden on the slide, that if the terms are uncertain, then it's more likely to be a moral obligation rather than a trust. He does, however, note that determining whether there is a trust-like obligation in situations of informality such as these is always going to be a problem. And he refers to the case of Golden Hill, which was described by the judge in that case as being analogous to a secret trust on the basis of its informality. Now, in that case, the nominee under an insurance policy on the wife of one Gilbert was told by Gilbert over drinks before dinner at a hotel, "If anything happens to me, you will have to sort things out. You know what to do. Look after Carol and the kids. Don't let that bitch," i.e. Gilbert's wife, "get anything." The general intention was clear, but the specifics were not. So was there a trust? The court held that notwithstanding an apparent lack of clarity as to the terms of the trust, the intention for Carol and the kids to benefit was clear. So they held a trust in Carol's favour for the benefit of herself and her children, and ensured that Gilbert's wife, who we referred to so charmingly, didn't receive anything in terms of an equitable interest. So Moffat makes the point that intention isn't always necessarily 100% clear in terms of the terms of the trust, but sometimes the court is still willing to uphold the secret trust if the intention for the existence of one generally is present. Interestingly, going back to the case of Snowden, the solicitor had actually advised the use of a secret trust, and McGarry, in his judgment, acknowledged the use of the mechanism as a device for undecided testators without taking the opportunity to denounce it. Remember earlier, we said that there are two reasons for wanting to create a secret trust. The first was obviously to maintain secrecy, but the second was in case of hesitancy. Now, most commentators criticise that second reason, McGarry had the opportunity to formally denounce it in the case of Snowden, but didn't do so. Now, in the case of Snowden, the solicitors taking instructions for Mrs. Snowden's will kept detailed notes of their discussions with her, and these were admitted as evidence. Now, this is standard practice. In the event of a dispute as to the existence of a secret trust, though, the standard of proof, according to the judgment in re Snowden, is the ordinary civil standard of proof, i.e. the balance of probabilities. Turning to the second of our requirements in a little bit more detail, there must be communication of the intention and also the terms of the trust. So communication and acceptance of the trust obligation may take place in the case of a fully secret trust at any time during the lifetime of the testator, whether before or after the execution of the will. So, on the authority of Walgrave and Tebbs, the settlor must communicate the fact of the trust to the secret trustee before their death. Thus, it was held in Walgrave and Tebbs that the secret trustee can take absolutely where the existence of the secret trust hasn't been communicated at all. But what is it specifically that must be communicated? Well, it's not only communication of the existence of the trust that has to be communicated, but also the detail of it. So the terms of the trust have to be communicated prior to death. And that's on the authority of Re Boys. So, as was quoted in that case, the devisee or legatee cannot, by accepting an indefinite trust, enable the testator to make an unattested codicil. So at the point at which communication takes place and is accepted, the terms have to be finalised. By contrast, we can look at the case of Re Keane. Re Keane is authority that if a trustee is handed a sealed envelope before the testator's death, but told not to open it until after the testator's death, this may still be held to satisfy the requirement for communication prior to the testator's death. So where the trustee knows in general terms that he's expected to act as a trustee, communication of the terms of the trust might in fact take place after death. The reason is, although the trustee is not privy to the full details until after the testator's death, he's accepted the obligation knowing this to be the case, and this is generally known as constructive communication. So in the circumstances where a sealed envelope is given over by the settlor to the intended secret trustee with instruction not to open until a later time, the situation is seen as analogous to a ship sailing under sealed orders, with Lord Wright saying, "A ship which sails under sealed orders is sailing under orders, although the exact terms are not ascertained by the captain until later." Extending that analogy, a trustee is nonetheless bound by the instructions, even though they're not aware of the full detail of the terms until later, as long as they've accepted sealed instructions as to how they're to act as trustee. And although Re Keane concerned a half-secret trust, it's generally accepted that this judicial flexibility would apply equally to both fully and half-secret. But as a general statement of principle, communication of both the intention and the terms requires that the trustee must know with sufficient certainty the terms of the trust before the death of the testator, or must at least have the means to ascertain the terms in the case of a sealed envelope. And this has been approved in the cases of Moss and Cooper and Re Bateman's will trusts. The third and final requirement in respect of fully secret trusts is acceptance. And having been told of the testator's intention that a legatee is to deal with the property in a certain way, it is incumbent on that legatee to elect whether or not to accept the trust. So the secret trustee must agree to act as such. This will normally be expressly stated, but silence can amount to acquiescence. So this third requirement is that the secret trustee must accept trusteeship by either communicating his consent to the settlor or by his silence, as for example where the settlor says, "I will assume you will do as I request unless I hear to the contrary," and the secret trustee makes no response. In Moss and Cooper, it was held that this, i.e. silence, would constitute acceptance of the trusteeship. The same case also confirms that communication broadly covers the requirements for fully secret trusts. But you'll remember earlier that we said there are two different types of secret trusts. The second being half-secret trust, sometimes also referred to as semi-secret trust. And in Blackwell and Blackwell, Lord Buckmaster set out the requirements for a half-secret trust to be hopefully familiar as intention, communication, and acceptance or acquiescence. That is, there needs to be an intention on the part of the settlor to subject the secret trustee to an obligation in favour of the secret beneficiary. There needs to be communication of that intention to the secret trustee and acceptance by the secret trustee of that obligation, either expressly or by acquiescence. In the case itself, the testator by a codicil gave £12,000 to 5 legatees for the purposes indicated by me to them, and it was held that the trusts were communicated and accepted prior to the execution of the codicil, and the House of Lords enforced the trust. We can see then that the requirements for half-secret trusts closely resemble those for fully secret trusts, but the major difference is around communication. As can be seen from the slide, communication in a half-secret trust to the secret trustee must be prior to or at the time of the execution of the will, and acceptance of the obligation by the secret trustee must also be prior to or at the time of the execution of the will. There are two reasons put forward for this. Firstly, the trustee must know the terms of the trust in order to decide whether or not to accept trusteeship, and as the trust is on the face of the will, the testator, secondly, is not allowed to use the trust, the secret trust, as a mechanism for delaying the time at which he'll make final decisions on dispositions, as was stated by Lord Sumner in the case of Blackwell itself. A testator cannot reserve to himself a power of making future on-witness dispositions by merely naming a trustee and leaving the purpose of the trust to be supplied afterwards. But can you see any difficulty with this reasoning? Well, it's unfair in relation to fully secret trusts. Remember, for fully secret trusts, communication may take place any time before the death of the testator. And so this latter rationale about a testator not being allowed to use the secret trust as a mechanism for future on-witness dispositions can be criticised, as it appears to penalise the testator who uses a half-secret trust, whereas indecision appears to be indulged for those who choose a fully secret trust, and the rules seem to be somewhat arbitrary in nature. Nevertheless, the distinction is drawn, and in a half-secret trust, communication and acceptance must take place before or at the time of the execution of the will. Now, we are in fact already familiar with the case of Re Keane on the issue of constructive communication very generally, but actually it's an illustration of the point made on the previous slide about a testator not being allowed to reserve to themselves a power of future on-witness dispositions. And in the case itself, the testator gave to his executors and trustees the sum of £10,000 to be held upon trust and disposed of them by them among such persons or charities as may be notified by me to them during my lifetime. The terms of the will, therefore, pointed to a future disposition, something that had not yet happened at the time of the execution of the will. However, before making the will, the testator had handed a sealed envelope to one of the trustees containing the names of the proposed beneficiary, with instructions not to open the envelope until after his death. And the question arose for the court as to whether the £10,000 should be held on trust or not. It was in fact held in the case that no valid secret trust had been created, because the will pointed to a future disposition, and the reservation of a power by the testator to make future unattested dispositions was contrary to the Wills Act. The communication of the terms of the trust prior to the will was inconsistent with the provisions outlined in the will. The case did, however, confirm that the sealed envelope would have been fine, but for that point. So if the will had have said, on the terms I have already communicated, then that would have worked. And so Lord Wright's comments about the ship sailing under sealed orders were technically obiter, as the will itself pointed to a future disposition, but the principle has nonetheless been accepted. Similarly, on the point of future unwitnessed dispositions, the case of re Bateman's confirms the same point. In that case, a settlor directed his trustees to pay the income out of part of his property to such persons as shall be stated by me in a sealed letter to my trustees. Again, here it was held that the words shall be indicated that the settlor was allowing the possibility of later dispositions, and so the trust failed. Here, the settlor was reserving power to alter his will by naming a trustee and then making unwitnessed dispositions in the future. This contravened the Wills Act, and so the trust was invalid. But of course, remember, re Keane does give us the point that a sealed letter can work as long as it's handed over at the relevant time, as long as the will isn't inconsistent with the instructions in the sealed envelope. What we can say is that if a will points to a future communication, even if the terms are contained in a letter, then the trust will fail. Re Keane has been criticised, but was followed in Re Bateman's will trust, in that communication by letter would have been acceptable if the will hadn't pointed to future communication. Finally, specifically on the point of half-secret trusts, we come to the third requirement of acceptance. And again, the intended trustee must accept the office of trustee and acquiesce in the terms of the trust. Now note, from the authority of Blackwell and also Moss and Cooper, this may be by express promise, by tacit promise, or implied by silence. Again, acceptance has to take place at the time of or before the execution of the will. Finally, for this part of our podcasted lecture, let's just consider the possible consequences of failure of secret trusts. And when a secret trust fails, the property is dealt with in one of two ways. Firstly, the named legatee could take absolutely. As an example of this, see the case of Walgrave and Tebbs. There, a testator had left £12,000 unto and to the use of Tebbs and Martin, their heirs and assigns, forever as joint tenants. Oral and written evidence was presented to the court which demonstrated both that the testator had intended the property to be held on secret trust, but also that at no time had he communicated that fact to Tebbs and Martin. And on the basis that they had no knowledge of the intention to create a secret trust, they were able to take absolutely. In re Boys, the testator left all of his property to his solicitor, but this was to be held on trust that would later be communicated to him. This didn't happen before death, but afterwards. An unattested direction to benefit his mistress was found amongst his belongings. And the solicitor actually wanted to carry out the obligation in favour of the mistress, but the testator's family contested the validity of the trust on the basis that the terms, even though the terms hadn't been communicated during the settler's lifetime, and the court held that it failed. It was held that in such a circumstance, the named legatee would be required to hold the property on a resulting trust for the testator's residuary estate. No, re Boys was a fully secret trust case, and so where there is knowledge of the existence of a trust but not the terms, then a fully secret trustee will be required to hold on resulting trust. In the case of a half-secret trust, it will always be the consequence that the half-secret trustee, on failure, would have to hold on resulting trust. This is because, on the face of the will, it is evidence that no beneficial interest is intended to the secret trustee. It's obvious from the face of the will that they're intended to take as a trustee. That concludes part 2 of our podcasted lecture. In the next part, we will have a look a little bit more about some peripheral matters, and we'll come on later on to consider the theoretical basis for secret trusts. Hello and welcome to this, the third part of our podcasted lecture on secret trusts. In the first two parts, we'll be considering generally a reminder of the law of succession, the formalities as set out in section 9 of the Wills Act, and generally what secret trusts are, as well as then looking in a bit more detail about the distinction between fully secret and half-secret trusts, and the technical requirements that apply to each in terms of intention, communication and acceptance, and the difference in timing for communication between fully secret and half-secret trusts. We now move on in this next portion to consider some general other matters to note in relation to secret trusts before considering the theoretical basis on which secret trusts operate. Before we can move on though to consider any of these additional matters, there is obviously a natural problem in these cases of proving the existence of secret trusts. If these arrangements all come about orally through discussions and through conversations, then actually establishing that they ever took place at all is naturally a problem for the parties concerned. Now with half-secret trusts there is less of a problem because the fact of the trust can be seen from the will, but the terms nonetheless are still generally discussed orally, and therefore actually proving the content of the trust can sometimes be difficult. With fully secret trust, there is no indication in the will at all that a legatee is a secret trustee, and those cases are naturally particularly difficult. A prudent testator would give the secret beneficiary some form of written evidence, a letter or a note of some kind. Or, of course, indeed, as was noted in the case of Rhys Snowdon in discussions in the previous part of the podcast, solicitors taking instructions in respect of the will would keep detailed attendance notes, detailed file notes, which could be admitted in evidence. But because communication can be oral, this does have a problem in terms of proving the existence. So testators are, of course, advised to take the practical precautions, though this is not a legal requirement. If there is any dispute at all as to the possibility of the existence of a secret trust, then on the authority of Rhys Snowdon, it is the ordinary standard of proof that should apply. That is the ordinary civil standard of proof, i.e. on the balance of probabilities. Turning our attention now to the other points to note in relation to secret trusts, then we must consider the issue of co-ownership. And where property is left to two or more persons to act as secret trustees, secret trustee number 1 and secret trustee number 2, for example, but the trusts are communicated to and accepted by only one of them, then the position is as reluctantly stated by Lord Farwell in the case of Rhys Stead. And if the gift is made to them as joint tenants, then they are both bound where the trust is communicated to one prior to or at the time the will is made. Now, if the will is left unrevoked on the faith of a later promise by one only, the trust binds only the promisor. So, if communication and acceptance to one potential secret trustee is after the will, only that person is bound. But if it takes place before the will and only to one of them, then both secret trustees are bound. Or if you have 3 joint attempts, all are bound. In the case of tenants in common, where the secret trustees hold in property as tenants in common in defined shares, then only those who agreed to the trust before the testator's death are bound. Many have criticised these rules, but they are nonetheless the rules that should be followed on the authority of Rhys Stead. In terms of whether the distinctions can be justified, Perrins in particular has been particularly critical in his article back in 1972, Can You Keep Half a Secret? And the distinctions in Rhys Stead on the timing of acceptance are difficult to support as a matter of policy. And Perrins has suggested that gifts on secret trusts in these situations should be decided on the principle in Huguenin and Bazley, that is, no man should profit from the fraud of another. On this argument, the second secret trustee would only be bound if the testator was in fact induced to leave property to him on the strength of the first secret trustee's promise, but not otherwise. It's been suggested then that it would be better to assess whether or not the bequest was actually induced by the promise in either case, rather than to create general rules, as has been done in the case of Rhys Stead. In the case of half-secret trusts, then the trustees should be identified as such on the face of the will, and any communication and acquiescence, as we already know, must be before or are at the same time as the will is executed. And therefore, we'll never run into the problem of co-ownership and having different rules for different timing in respect of half-secret trusts, because communication will always take place to all relevant parties before or at the time of the execution of the will. So in the case of half-secret trusts, all will be bound. Another peripheral point to consider in the matter of secret trusts is whether or not the trustee can take a benefit, i.e. can a trustee introduce any extrinsic evidence to demonstrate that they are allowed to take some of the property beneficially themselves. Now, a secret trustee may claim that the testator intended him to take some benefit from the gift, for example, as a specific sum for performing the trust, a sort of reward, if you will. Now, difficulties arise here in ascertaining the testator's intention, and also as to how far such evidence is admissible in favour of the trustee. In Rees will trust, the testator left his entire estate unto my trustees, absolutely, they well knowing my wishes concerning the same, and a substantial surplus remained, and the trustees claimed that the testator had said that they should retain any surplus for themselves. The court, though, held that the evidence was inadmissible, and they couldn't show that the trustees were to take a benefit, as in a proper construction, the will imposed the trust on the whole amount. But that was a half-secret trust case, and the principle is generally taken, therefore, to mean that in the case of half-secret trusts, the answer is no. The trustee cannot introduce any extrinsic evidence to demonstrate that they are allowed to take beneficially. However, in Reed Tyler, a fully secret trust case, there are suggestions that evidence may be admitted as to all of the terms of the trust, although such evidence will not necessarily be received lightly. Also, see the case of Ottaway and Norman on the same point. Miss Hodges was, in fact, if you recall, able to enjoy the benefit of the bungalow during her lifetime first, before she was bound to pass it on to Mr. Ottaway Jr. in her will. And so it is plausible that in a fully secret trust, evidence can be admitted to show that a trustee can take some form of benefit from the trust property. Now, having considered the other matters to note with respect to secret trusts, we now come on in this final part of the podcast to consider the mechanism by which secret trusts operate and the equitable doctrine under which they are enforced. And so the operation of secret trusts, as we've seen, conflicts with the provisions of the Wills Act. Its effect appears to validate a testamentary disposition, which fails to comply with fairly straightforward formal requirements contained in the Wills Act. So the operation of secret trusts appears to override many formalities in statute. It in fact overrides formalities in the Law of Property Act, as well as in the Wills Act. The case of Ottaway and Norman concerned a fully secret trust over land, when no written formalities were required. Had that been an express trust over land, written formalities would be required. How can this apparent complete disregard of statutory provisions be justified? Well, several theories as regards the operation of secret trusts have been put forward in order to justify the court's apparent complete disregard for these statutory provisions. Let's take a look at the three major. The first of these is that the doctrine is explained in relation to the probate doctrine of incorporation by reference. This is a theory which is in the main concerned with formality in testamentary dispositions and being able to pull something in alongside the will to incorporate it to be enforced with the will. Secondly, we'll consider the historical justification based on the fraud theory as it's known. And thirdly, we'll look at what is sometimes termed the modern view, that the trust operates outside or en dehors the will. Starting then with our first theory, which has been used to justify the operation of secret trust. Incorporation by reference is a probate doctrine which allows a separate document to be incorporated into the terms of a will under clearly limited circumstances. It's important to appreciate that the doctrine can only operate if the testator has otherwise satisfied the normal requirements of the Wills Act. So this doctrine operates to allow a testator within very clear limits to expressly incorporate another document along with the will. In this limited exception to the norm, a document will be incorporated provided it complies with a certain number of rules. Firstly, it needs to be referred to in the will. Secondly, it needs to be in existence at the time of execution of the will. And thirdly, it needs to be precise, i.e. there needs to be no degree of ambiguity at all. Note that when something complies with these three rules and is therefore then incorporated into the will, then it is admitted alongside the will to probate. Therefore, it too becomes open to inspection. So there is no secrecy with incorporation by reference as the incorporated document is admitted alongside the will. However, it has been argued by some that it is an extension of the principle of incorporation by reference that justifies the operation of at least one of our types of secret trust. The doctrine of incorporation by reference has been argued to be the basis for the operation of half-secret trusts, and Matthews in particular, in the article noted on the slide, is a strong proponent of this. Now, the argument is based on the extension of the rule around incorporation to include oral communications, and this would appear to explain the much criticised distinction in the operational rules relating to the timing of communication and acceptance. However, although the two doctrines share some similarities, this theory has been rejected by the vast majority of legal commentators, who argue that the distinctions between the doctrines, secret trust and incorporation by reference, are clear. Firstly, a document must be in writing to be incorporated, whereas a declaration of trust can be oral, i.e. this is a rejection of the extension argument. Secondly, acceptance is central to the trust doctrine, and it's irrelevant in the incorporation doctrine. Of course, the theory's biggest flaw is its lack of analysis for the justification of secret trust, a fully secret trust that is. It might go some way to explain a half-secret trust which refers to some additional communication, but of course a fully secret trust looks like a gift on the face of the will and makes no reference to any external or extraneous communication at all. Perhaps the most fundamental flaw, though, actually, with incorporation by reference is that which is noted on the previous slide. There is no secrecy. As soon as something is incorporated into the will by reference to it, then it is admitted along with the will to probate. Therefore, it becomes part of the public document, which is open to inspection by anybody willing to pay the relevant fee, and therefore it wouldn't be secret at all. So incorporation by reference were the basis for secret trusts. It would defeat the object of secrecy. The traditional view is presented as the fraud theory, and this is based on the equitable maxim that a statute cannot be used as an instrument of fraud. The fraud view is in line with the equitable doctrine illustrated in Rochefoucauld and Bousted, which does not allow any person to rely on their common law or statutory rights to perpetrate a fraud. And so you'll see the maxim described variously. Equity will not allow statute to be used as a cloak for fraud, as an instrument of fraud, as an engine of fraud. But the doctrine has been accepted as far back as the case of Thin and Thin in the late 17th century, and of course was explicitly acknowledged in the case of McCormack and Grogan to be the basis upon which secret trusts were at the time viewed to operate. In the case of McCormack and Grogan itself, the House of Lords stated that the secret trustee should not be allowed to profit by his own fraud through disregarding his undertaking that is given to the testator. And Lord Westbury is quoted as saying, "The jurisdiction which is invoked here by the appellant is founded altogether on personal fraud. It is the jurisdiction by which a court of equity, proceeding on the ground of fraud, converts the party who has committed it into a trustee for the party who is injured by that fraud." Now, this basis worked well in many respects for fully secret trusts, because otherwise the secret trustee would take beneficially. But this narrow view of fraud doesn't really work for the enforcement of half-secret trusts, where the secret trustee, being named in the will as a trustee, can never profit from non-enforcement of the secret trust. So the fraud theory offers, on the face of it, very little to explain half-secret trusts. Furthermore, why would the imposition of a resulting trust not resolve the difficulty in circumstances where a secret trust wasn't established to the satisfaction of the court? If the justification of the fraud theory is to prevent the secret trustee from personal gain, why not impose a resulting trust instead? Why hold that the secret trustee holds on trust for the intended beneficiaries? Surely a resulting trust would still achieve the aim of preventing fraud. However, in Blackwell and Blackwell, a half-secret trust case, Lord Buckmaster did say that the real beneficiaries, i.e. the secret beneficiaries, would be defrauded unless evidence of the trust could be given. So the wider view of fraud is that the potential fraud is not merely concerned with the personal gain of the secret trustee, but with the frustration of the testator's intention and the destruction of the beneficial interest of the intended objects. And to impose a resulting trust would, in fact, often direct the property to those very people whom the testator clearly did not want to benefit. As Hodge indicated in his article, The Fraud Theory Revisited, back in 1980, the fraud lies in the fact that the secret trustee is attempting to defeat a beneficial interest which he has led the deceased to believe would belong to another. This is a fraud both on the deceased, whose confidence is betrayed, and on the secret beneficiary, who is deprived of the benefit. The fraud theory, however, has been criticised, and primarily this is in relation to the confusion as to the standard of proof required to activate the trust mechanism. Fraud obviously brings to mind connotations of criminality. Fraud itself is criminal, so one would expect the criminal standard. Note in McCormack and Grogan, it was stated that it is incumbent on the court to see that a fraud is proved by the clearest and most indisputable evidence, therefore suggesting that the criminal standard would be applied. However, in Rees-Snowden, the language ordinary standard of evidence was used, suggesting only the civil standard. And although flexibility is a key feature of the equitable jurisdiction, for reasons of certainty, it's argued that it should follow established principles, and this confusion as to the standard of proof is one area of uncertainty in relation to secret trusts. And it can be, secondly, criticised on the basis that if we are to justify circumventing parliamentary sovereignty, circumventing statute, then surely we should only do so on the clearest and most indisputable of evidence, and not merely on the civil standard of the balance of probabilities. The modern and, to many, more acceptable view, though not to everyone, and not to me personally, was expressed by Viscount Sumner in Blackwell and Blackwell, who said that evidence of the trust could be given because the communication and acceptance of the trust during the testator's lifetime took the matter outside of the Wills Act. This is an expression of the auditor, or outside basis of enforcement. So this view classifies secret trusts as independent, express trusts which operate outside of the will and are therefore not subject to the formalities of the Wills Act. They are declared on communication but constituted on death. And in this view, the trust arises because of personal obligation accepted by the legatee, i.e. the secret trustee. Note pronunciation is often anglicised in law. So although this comes from the French for outside, ODO, you'll often hear this said as the dehors the will theory. Unfortunately, that's just the nature of lawyers. We take foreign phrases and put them into an English accent. So if you hear that, please don't recoil in horror at the awful pronunciation in French. This is the standard legal pronunciation. And whilst this theory doesn't necessarily have universal academic support, it has found a significant degree of judicial support. Ree Young is one such example where Mr. Justice Danckwerts expressed quite strong support for the dehors theory. And we've already encountered Section 9 of the Wills Act, which tells us that in order to be valid, a will must be in writing, signed and attested by 2 or more witnesses. Now there is another important section of the Wills Act, Section 15. Now according to this section, a witness to a will cannot normally be a beneficiary under it. And the reason for this section is to avoid any undue influence or duress. If someone who is to take a benefit under a will is present at the time of the execution of the will, then there is a possibility or a suspicion perhaps that they could have somehow influenced the testator to have made the disposition in their favour. So section 15 precludes any witness to the will from taking a benefit under the will. But if we accept the De Haas theory that a secret trust is an express trust arising au dehors the will, i.e. outside the will, it would be possible then for a witness to a will to be the secret beneficiary under a secret trust, which merely becomes constituted by the operation of the will. In other words, the gift is as a result of a prior express declaration of trust rather than as a result of the will, and so therefore you could say the secret beneficiary is outside of the mischief of section 15. And this is the view that was taken by Mr. Justice Danckwerts in Re Young, where he said the whole theory of the formation of a secret trust is that the Wills Act has nothing to do with the matter, since the persons do not take by virtue of the gift in the will, but by virtue of the secret trusts imposed upon the beneficiary, who does in fact take under the will. So in Re Young, precisely the event happened with one of the secret beneficiaries witnessing the will of the testator, and it was held that they could take the benefit under a secret trust on the basis that they didn't take by virtue of a gift in the will, they took by virtue of an independent express secret trust. The idea of the De Haas theory has also been accepted by Mr. Justice Romer in Re Gardner number 2. And before we consider this case, note that it's generally accepted that secret trusts are constituted at the moment of the testator's death, and that's consistent with general trust law. It's also consistent with general probate law. Will trusts are constituted when legal title vests in the trustee. That can only happen when the testator dies, and by operation of law, legal title vests in the executor, who is then under a duty to vest it in anyone named in the will as trustee or as a legatee. So that makes perfect sense. However, the case of Re Gardner seems to suggest that the doctrine of lapse, which applies generally to wills, doesn't apply to secret trusts, and also seems to suggest that a trust can be constituted before it would otherwise generally, legally, be viewed to be constituted. In the case of Re Gardner number 2, a testator set up a secret trust in a will, but one of the secret beneficiaries predeceased the testator, and it was held that the gift didn't lapse and that the secret beneficiary's estate could claim the share on the basis of the De Haas theory, on the basis that the gift was created at the date of the will, and that the trust was effectively constituted and irrevocable at that point. Now, the decision has been criticised in that in order for a beneficiary to be entitled to an interest, the trust must be fully constituted by the vesting of legal title in the trustee, and that doesn't occur until the death of the testator. And consequently, the predeceasing beneficiary's estate ought not to be able to take. In other words, there is no transmissible interest until the testator's death. It has been criticised widely, and it is suggested that the decision cannot be correct in principle. Hudson, in particular, writes on this point. As well as ignoring fundamental principles of trust law, it also ignores the doctrine of lapse in probate law, which is enshrined in section 25 of the Wills Act, which we have in fact seen elsewhere when we looked at express trusts. But in a nutshell, if a person is due to inherit under someone else's will, and they die before they're due to inherit, their gift is said to lapse, simply. And so the secret beneficiary in Re Gardner ought to have experienced that their estate should not be able to make a claim because the gift ought to have lapsed. Nonetheless, the case is technically good law, in inverted commas, in that it hasn't been overruled, but given the strength of general feeling against it, if the matter were to come up again today in a court of sufficient seniority or authority, it is most likely anticipated that it would, in fact, be overruled. The De Haas theory can be criticised as it classifies secret trusts as express trusts, And so accordingly, if they are independent and indeed inter vivos express trusts, which merely use a will as a constituting mechanism, then they should comply with the formalities for inter vivos express trusts. Therefore, when they concern land, they should be evidenced in writing. Recall that section 53(1)b of the Law of Property Act requires that any declaration of trust concerning land must be manifest and proved in writing. But we're already familiar with the case of Otway and Norman. Remember, part of that estate concerned a bungalow, and the arrangement there was entirely oral. Now, that was upheld. The judgment itself was silent on the point of section 53(1)b, but nonetheless we do have a case in point which seems to go against the Dehors principle of it being an express trust, as a secret trust was upheld without compliance with express trust formalities. Also, if secret trusts arise outside the will as express trusts, then the execution of the will is entirely irrelevant. And so that therefore doesn't explain the somewhat arbitrary distinction between the requirements for a fully secret trust and a half-secret trust in relation to the communications rules, that is, in relation to the difference in the timing requirements for fully and half-secret trusts. So it seems that the Dehors theory itself is not satisfactory. So none of the theories seem 100% to fully justify the existence of secret trusts. Nevertheless, they are enforced, and academics have sought for many years to try and justify their continued usage and enforcement. An examination of the theoretical justification for the enforcement of secret trusts throws up another question as to their classification. Are they really express, or are they constructive, i.e. implied? The Dehors theory classifies secret trusts as inter vivos, express trusts, which are executory as they take effect upon the testator's death, when the will vests the property in the trustee. So they say that the declaration of trust is independent of the will, but the will is the formality chosen to constitute the trust, i.e. the will vests the property in the trustee. The criticism of this theory, though, is that secret trusts and express trusts have different formal requirements, as evidenced on the previous slide with reference to the case of Otway and Norman, which didn't comply with express trust requirements, but nonetheless led to a finding of a valid secret trust over land. Nonetheless, some have argued still that they are express, created inter vivos by agreement between the testator and the trustee. The quote on the slide being illustrative. Secret trusts are express trusts, and recognising and enforcing them does not require anything that equity does not already do in respect of other express trusts. And this is a view held by many proponents of the Dehors theory. The second way in which secret trusts are classified is as constructive trusts, that they are implied by law on the conscience of the constructive trustee, on the basis of it being the conscionable, equitable thing to do, and that the reason which they don't have to comply with express trust formalities is by dint of section 53(2) of the LPA, which provides that implied, resulting, or constructive trusts do not require formalities in their creation. So the constructive trust comes into existence by operation of law on the basis that it is about preventing fraud and preventing unconscionable conduct. As to whether they're express or constructive, though, does it really matter? The formalities of section 53, subsection 1 of the Law of Property Act apply to express but not constructive trusts by virtue of subsection 2. Therefore, trusts of land require written evidence. We've already seen Otway and Norman, where non-compliance with 53(1)b was not a bar to the enforcement of an oral secret trust of land. That was a fully secret trust of land, and that's led many to conclude that secret trusts are constructive in nature. However, the key case of Reed Bale shows that a half-secret trust of land was not enforceable in the absence of written evidence, and analysis of these cases has led some commentators to argue what is known as the split view, i.e. that fully secret trusts should be classified as constructive trusts and half-secret trusts should be classified as express. But, as Otway and Norman is a much more recent decision, it suggests a greater flexibility on the part of the courts, and the principle in relation to half-secret trusts is by no means clear. It's argued, therefore, that the question as to whether secret trusts are express or the formalities of both the Wills Act and the Law of Property Act are both designed to prevent fraud. If the Wills Act can't be used as an instrument of fraud, then neither can the Law of Property Act. The doctrine surely has to apply to both. And whether express or constructive, secret trusts are seemingly not affected by any statute requiring formality. The argument is therefore arguably academic. There are, however, innumerable discussions on this point, and academics have for many years tried to wrestle with this point, as have the judiciary. And you'll see a lot written in the texts and in journal articles on the justification for secret trusts. You'll also find some interesting observations in your suggested reading for the workshop on secret trusts in due course. Finally, on this slide is just a simple summary of the difference between fully and half-secret trusts. In a fully secret trust, the trust and the ultimate beneficiary are not identified on the face of the will, and all that we appear to see is an outright gift in favour of the secret trustee. But there will have been a secret communication somehow, whether that be oral or otherwise, with the secret trustee to tell them that they are in fact to hold for the secret beneficiary. Communication can take place any time during the testator's lifetime. In fully secret trusts, there is the possibility of future dispositions after the will, and on failure, it is possible that the legatee could take absolutely if they had no knowledge of even the existence of a secret trust. If they had knowledge of the existence but not the terms, then they would have to hold on a resulting trust. In the case of a half-secret trust, on the face of the will, the trust but not the ultimate beneficiary appears. So we can see straight away that there is an arrangement in existence, we just don't know what the exact nature of that arrangement is. Communication here has to be before or at the time of the will. There is no power of future dispositions, and on failure, the legatee will always hold the property on resulting trust. It can never take beneficially. That concludes the third and final part of our podcasted lecture on secret trusts.